And I would love to officially welcome everyone to CGS's flagship program, an oldest running program, our World Citizen Book Club. In today's installment, we're with Jennifer Trahan to explore her book, The Existing Legal Limits to the Veto Power. Jennifer Trahan is a clinical professor of global affairs at NYU and convener of the Global Institute for the Prevention of Aggression. She has published scores of law review articles and book chapters, including on the International Criminal Court's crime of aggression. And this book that we're here to discuss, Legal Limits to the Security Council Veto Power in the Face of Atrocity Crimes, was awarded the 2020 Book of the Year Award by the American branch of the International Law Association. She's also authored 2 digests compiling the case law of the ad hoc tribunals and serves as one of the U.S. representatives to the the Use of Force Committee on the International Law Associations, and holds various positions with the American branch, including as co-chair of the ICC committee. And Jennifer, well, I'm sorry that my colleague, our usual moderator, cannot join us today. It gives me the pleasure of introducing you also as my dear mentor and friend and inspiration. And I do hope that in addition to the very rich subject matter that we're here to discuss today, the existing legal limits to the veto power, we might hear a little bit, of course, on your path-breaking work on the crime of aggression and some of the work that you've been doing galvanizing around threats to the rule of law and the independence of the judiciary, such as sanctions on the ICC. We have deviated from our normal book club format a little bit for this session, in that we are exploring just the introduction and chapter 1 of Jennifer's book, which goes into a great degree of technical detail and is incredibly legally rich. I do advise everyone to read the book in full. We can make it available to you if you have not already had the pleasure of reading the full volume. But for today's purposes and for an audience of non-lawyers, for the most part, I know some of you are, and I'm sorry to admit that I'm in that club, we have decided to stick with this portion of the book. And also this can bridge us, I think, into a discussion of advocacy, and that in which CGS and our partners within the World Federalist Movement are actively engaged to rectify some of the imbalances and injustices that Jennifer's arguments highlight. So with that, Jennifer, please take it away.
Super. Thank you so much, Rebecca. And thanks for that overly kind introduction. And it's a pleasure to be here and to see Ellen and Susanna and Alan as well. I was asked to start with what motivated me to write this book. So the title, Existing Legal Limits to the Veto Power in the Face of Atrocity Crimes. Let me start by saying atrocity crimes, just imagine that shorthand for genocide, war crimes, and crimes against humanity. It is in my book. I do actually have a later article that says, well, I also want to include the crime of aggression. I started less ambitiously and later expanded it. But just think of genocide. So there's atrocities occurring. The Security Council has a plan to perhaps try to prevent or stop them. And one of the P5 vetoes it. So you veto the plan to stop, you're allowing the atrocities, right? If, we're having genocide in Darfur and Russia is going to, or China is going to block a plan, they're, in my mind, enabling the crimes, but no one seems to ever really look at it that way. So as a lawyer, I thought, well, let me look at the system of international law. It also sprung out of my teaching because so often students would ask, well, why don't we have a Myanmar tribunal? Why won't we have accountability for the Uyghurs? Why wasn't a Syria tribunal created? And so many times the answer goes to the veto. Okay, Russia was backing the Assad regime. China doesn't like accountability and will block any tribunal in Asia or referrals to the International Criminal Court. So sometimes, and we've all seen even like humanitarian assistance blocked. And then you start going, well, is that a proper use of a power granted under the UN Charter when starvation is a war crime? Is that really the charter as it was intended? You block food aid? And I started saying, we have to think of this in a more conceptual way. So my students, and I would ask my students, well, why don't we have these? And they were like, is it the veto? And I'm like, it is the veto. And then the other thing I think that motivated me, I was here in New York when Russia was doing all its huge series of vetoes related to Syria. And the legal advisors and ambassadors were so upset. And being here and working with them, you just felt it. And you're just like, they have a plan to try to rein in chemical weapons, veto. Food assistance, veto. Aid in the siege of Aleppo, veto. Like every good idea they're having, and you're seeing the atrocities, on the television, a siege of Aleppo, that goes back to medieval ages, a siege of a city. We're going to starve out the city. And they have a plan to give aid, vetoed. And they were, and the elected 10, they were really upset. They had plans to try to help. So being in New York, somehow also just feeling this palpable upset. And now we've felt it again, I think, in the Gaza situation. We could have had a ceasefire, more than a year ago. What, 25,000 more people would be alive if we had? I mean, because there's just this direct link. I mean, it's like a direct linkage between someone raising their hand and large numbers dying on the ground. So I'm trying to make that linkage. So, and to, in the end of the day, suggest a legal argument, that this situation could be challenged at the International Court of Justice. And this is, of course, where my work overlaps with Citizens for Global Solutions and their Law Not War campaign, which is all about making more use of the International Court of Justice. Because basically, we've talked about reform of the Security Council for like 30 years. Like we should add new permanent members, would they have the veto or not? Can we restrain? And it's nicknamed the unending committee. Like they never get anywhere. So I'm like, well, maybe we need to go to an outside body, the International Court of Justice, to get a ruling. And in my book, I argue for an advisory opinion just on the veto. Is it above all law, or do we have a problem if it's aiding genocide? And I obviously, argue we have a problem if it's aiding genocide. So to go, I know you probably, hopefully, maybe read my intro and maybe chapter 1. So I'll kind of go over the chapters, a little more detail in chapter 1. And I'll just talk for, maybe 10, 15 more minutes and then take your questions. If we have extra time, happy to talk about the crime of aggression and sanctions on the ICC, but let's do vetoes first. And, we'll see how the time is. So my section starts with the UN Charter. Like, how did we get this veto power in the Charter? And it goes back to the negotiations, and it's remarkable to read them because it was Stalin and FDR and Churchill. Right. And Stalin wouldn't meet in the same room as the Chinese, so that those were separate. And France was a P5 very late in the day, so they're not part of the negotiations. At that point, they're calling it the principle of unanimity. And they decided they needed this extraordinary veto power because the assumption was they'd be the major troop contributing countries. And they're like, well, if we're going to commit our troops, we want the veto. And just think of it, like the P5 aren't our major troop contributing countries. So their whole supposition for needing it isn't how things have turned out. And there was a real back and forth because Stalin says unlimited veto power. And the US and UK said, yeah, but if you're involved, you shouldn't have the veto. If you're in the country, if you're involved in the dispute, you shouldn't have. And that went around for multiple rounds of negotiations. And, Stalin's like, no, unlimited veto power. And US, UK. And just think if the US and UK had prevailed, it would mean Russia can't veto a resolution on Ukraine. And because of Russia's veto, like the Security Council has done nothing on Ukraine. because Russia's involved. And if we'd had that, but we don't. We do have a modified version of it, and no one focuses on it. And I've separate articles on this. It's not in my book, but the veto, it's the Security Council's main power is under Chapter 7, and there there isn't the disqualification. There is voting under Chapter 6. That's not where their mandatory power is, but there is language. It's 27.3 of the charter. It actually says a party to the dispute is disqualified from voting. And states aren't using it. I have a separate article saying states could make much more use of this. If you tried to create a Ukraine aggression tribunal using under Chapter 6, Russia should be disqualified. And I've asked states, why don't you use this provision? And they're like, yeah, we never seem to use it. Nobody gives me a good answer. It was last used, I think, in 1960, but it's in, it's in the UN Charter, and it says when the council is under Chapter 6. Anyway, maybe a talk for another day, but there's more the council could be doing and they're not. Anyway, so those were kind of the fights. And then in the end of the day, Stalin kind of just won under Chapter 7. And yeah, you could, even if you're a party to the dispute, get the veto power. And then states coming into San Francisco are like, wait, why do you get this extraordinary power? And the US, and we have the famous anecdote. They said, you can tear up your charter if you don't want the veto power. And the US delegate like rips up the charter draft. So everybody's like, oh, okay, we want a UN, so we'll acquiesce to the veto. And then, what do we do when the Security Council is stuck? We often try to turn to the General Assembly, but it has much weaker powers. So, yes, we try. General Assembly can do what it can do. And it's interesting, I traced in my Chapter 1, already in 1946, they're pleading for voluntary veto restraint. They're saying, this power is blocking the UN. And so we have in the 1940s early pleas from the General Assembly, stop these vetoes. Then we have something coming in, the Uniting for Peace resolution. The US wanted authorization for the war in Korea. And they knew they wouldn't get it through the Security Council. Ultimately, they did because Russia wasn't there for the vote because they were protesting who was holding the Chinese seat. But they created this Uniting for Peace resolution. And it can take a matter what's stuck in the council and send it to the General Assembly. But to me, it can't create any more power in the General Assembly. So they can't do compulsory stuff. They can't commit troops. They can't create a tribunal. They could only recommend these things, and it's a huge difference. So that's kind of the framework under the charter system. Then I go through in my Chapter 1 an overview of some of the veto use. And I argue South Africa, the French, US, UK vetoes protected the apartheid regime longer. Ultimately, they didn't fully, but they did for a period of time. Rwanda, there were more veto threats. The US said, oh, you can't use this word genocide. And we won't back in, sending in any forces, even a limited force mandate, to shut down RTLM radio, seize machetes, So that's a veto threat. So my book also argues if we did something about the veto, it would also help with the veto threat. So the veto threat is really problematic as well because we don't actually even see it happening. So, when Russia vetoes, that does make the news. But when China usually uses a veto threat, and that's just kind of behind the scenes, and it never makes the news. So, why was the Security Council so limited in what it did in Darfur? It's all Chinese veto threats. And, you have to kind of delve into the weeds to figure out this is even happening. So that's almost even more pernicious. So Sri Lanka, like the council never does any accountability. Myanmar, we have one actual veto. It's an early signal. Yeah, you're not going to be able to do accountability for Myanmar. Darfur, I do a whole detailed chapter, chapter 5.2 in the book. And I trace rising atrocities, watering down peacekeeping, watering down their mandate. Peacekeepers get there 2007. The height of the atrocities is 2003, 2004, the height of the genocide. And it's because China's delaying and saying, oh, it should just be a hybrid deployment. And they get there years after the main height of the initial genocide. So genocide has resumed in Darfur. So I'm talking the initial genocide. So China is just hamstringing. And now we have Russia also. Russia is getting gold out of Darfur and just is doing vetoes now, note of humanitarian aid. Myanmar, an early veto by China, kind of a signal you're going to get nothing through the council. And then I trace a lot of the vetoes in Syria. That's also a half chapter in my book. You know, rising atrocities, veto of condemnation of crimes. We got like 5 of those. Chemical weapons attacks and 6 vetoes. No, you can't do anything about those. Veto of the referral to the International Criminal Court. Veto of humanitarian assistance. So I chronically the crimes in those last 2 chapters, both Darfur and Syria, crimes are rising. We have experts coming in and saying, you know, for Darfur, well, they're still dancing around the word genocide actually, but I mean, I think it's incredibly obvious. And for Syria, it is war crimes and crimes against humanity, but we're getting reports of all these crimes. It's not like we don't know this, and they're just vetoing. So that's kind of sets the foundation for the book. And then I mentioned that, you know, we've worked on Security Council reform for 30 years, and kind of the best we've done in this arena are 2 initiatives to voluntarily restrain the veto. They're called the French-Mexican Initiative and the ACT Code of Conduct. And they ask for a commitment from the P5 never to veto in the face of genocide, war crimes, and crimes against humanity. And only the UK and France agree. So my book argues, okay, we've tried this approach for 20 years and 2 P5 agree. So we aren't there. We are not where we need to be. 3 P5, and it's not like we could just hold our breath and, oh yeah, the US is about to commit not to use its veto. Yeah, no, not likely. And it's the same for Russia and China. So this approach is not working. It made great progress. And we've looked at, and we have for the ACT Code of Conduct, 120 plus countries. For the French-Mexican Initiative, over 100. They're formulated differently, but they're kind of doing the same thing. But they haven't got us where we need to go. My second chapter is on humanitarian assistance and R2P and where we are on that debate. It's kind of a separate issue. I'm happy to go into it if anybody wants to. It's not completely central to my vetoes arguments, so I'll kind of skip that for now. My third chapter goes into detail, the French-Mexican Initiative, the ACT Code of Conduct, what they say, what they're missing, where there are gaps, where we got a similar proposal from the elders. The US said it would be restrained in veto use. This was during the Obama administration. I think that promise went out the window. And I kind of compare and contrast these different initiatives. My fourth chapter is where I make my legal arguments. And I didn't assign it, it's very heavily legalistic. But I think of them kind of at 3 levels. And we have something called use cogens. So I apologize to the lawyers, you all know what this is. But for those non-lawyers, it's kind of, we say use cogens, I'm not sure literally. Maybe Rebecca can Google what it literally use the law of humanity or something. Use, but it's the sense
compelling law.
Compelling law. Yeah, it's not, that doesn't really. So it's this highest level. And we say the prohibition of genocide is at this level. And why do we do this? Because we actually are like, well, we don't care if a state hasn't ratified the Genocide Convention, you too are still bound not commit genocide because it's risen to this higher level. So we have these limited norms that we say you just cannot commit. Genocide, war crimes, crimes against humanity, the aggressive use of force under the charter system. So we do have slavery, torture. So we do have this highest level. So I argue to veto is inconsistent. If these crimes are occurring, you know, let's say genocide's occurring, there's a plan to stop it, and you veto, well, you're aiding genocide. You're at odds with this highest level. All actors under international law are bound to respect these norms. And at the end of the day, so are the P5. They are states. So they're bound as permanent members of the UN Security Council, and there's a lot of law. The Security Council is not above the law. States are not above the law, and they're certainly not above this highest level use cogens. And then in the International Law Commission spells out exactly what you can't do vis-a-vis use cogens. You can't aid. And I'm like, well, if you're vetoing a plan to stop the crimes, you are aiding those crimes. And I got that argument from our first war crimes ambassador, David Sheffer, under the Clinton administration. We're in the back of a cab in Sarajevo, and I was running through my arguments. And I was saying, I was making this one. He's like, and he's the first one that said, it's really aiding and abetting the crimes. And I said, yeah, you're right. So I've stuck with that formulation ever since, David, because I had a weaker formulation. He said, they're aiding the crimes. My second argument is that the veto comes from the UN Charter. So the UN Charter is framed, and you have to respect certain purposes and principles under the Charter, like adherence to international law. So I argue it's beyond their Charter power. And there's a lot of law that the Council is bound by the terms of the Charter. I mean, it's created by the Charter. So almost definitionally, they can't have power above it or to violate it. So that states, so we have to look, are these vetoes in accordance with the purposes and principles of the United Nations? It's Articles 1 and 2, and then you look at blocking food aid. Is that in accordance with the purposes and principles of the UN? It's clearly not. And, certainly endorsing this argument, Hans Corell, he was the head of the UN legal office under Kofi Annan. And, he has so much endorsed this argument and said, yeah, where does this is not a proper use of a charter power. I'm not doing this by myself. I have some really wonderful advisors, such as Richard Goldstone, who have served as sounding boards, these very prominent individuals. I've had, I have a number of Canadian foreign ministers have reached out. How can I help you with this? Canadians seem very interested. This is, we need to do this. So there are a lot of interest in my arguments. What I need is actually a lead state to take this on and move it. And that I have not yet found. My third level, so the second level is looking at the UN Charter. My third level of legal obligation is a treaty level. So the Genocide Convention. So I argue, okay, you're vetoing in the face of genocide. You're violating your Genocide Convention obligations. Or if war crimes are occurring, you're violating your Geneva Convention obligations. And all P5 are Genocide Convention, parties to the Genocide Convention and Geneva Conventions. So based on three pretty much independent legal arguments, I think you could prevail on any one of them to reach where I want to go, which is the veto isn't above the law. Like, stop blocking food aid, stop aiding genocide, stop, aiding atrocities through your vetoes. This is not a proper use of your power. So we need to get it to the International Court of Justice. I think an advisory opinion. So advisory, why advisory? We had the famous nuclear weapons advisory opinion. We've had famous advisory opinions. They're technically non-binding, but this is a very prominent court. They're taken very seriously. Because I'd like to frame the question in the abstract, because if you you take a particular veto, let's get the US on one of its Gaza vetoes, it gets political overtones. And you would have some countries who would be really enthusiastic, but I was shying away from that. So some countries, it is possible a veto in the face of genocide could be phrased as an interpretive question under the Genocide Convention, or a veto in the face of torture, an interpretive question under the Torture Convention on a particular veto. I think it's more neutral and more, we're just dealing with the law. And can you use the law to essentially aid atrocities? So I'm arguing for an advisory opinion question. So those are my arguments in a nutshell. What I have done so far, the book unfortunately came out in the middle of COVID. I did like 18 online book launches, but it's hard to kind of get the word out in the middle of COVID. I do now have a short film. So a filmmaker came to me And we were able to show that recently in The Hague, and I'm trying to set up a UN showing. It'll be in Geneva at a film festival, and if it gets picked up, then it should have distribution to lots of little short independent film festivals. So maybe the word will get out more, because I'm only me on this. I don't have an NGO. I'm a professor, so I don't have an NGO behind me. So I decided that a film could amplify my arguments. Then I also work with NGO partners, such as Citizens for Global Solutions, and other NGOs that have endorsed. So when I stop talking, I'll try to pull up my 2-pager that I should have queued up before. That lists, I have maybe 18 NGO supporters, and then high-level supporters such as Richard Goldstone and Hans Corell and a number of ambassadors. Yeah, so thanks, Rebecca. You put in I think the 2-minute. So we're not openly sharing the half an hour because we're still entering it in film competitions. And that is my way to hopefully to make some progress. In the end of the day, I need a state. So it's not NGOs or individuals. So I have to find a state who says, yes, we'll take this to the ICJ. And, certainly, I have certain states have sponsored my book launch events, and they've sponsored my meetings in The Hague. So I have some supportive states. No one has said, hey, we're going to run with this. So in the end of the day, I do need that. It's a long-term proposition. I tend to think under the Trump presidency might not be the right time to do this. I think states are going to be running scared. So, my arguments are out there. I try to make states aware of them. And, sometimes I speak with states and I'm like, well, why don't you push a veto, push an initiative in the Security Council, let them see that China is blocking this. They're like, oh, but we have an important trading relationship with China. So states are leery to take on the P5. So this is a really tough endeavor. So I have had Amnesty International UK was meeting with British officials on my behalf who were not going there. I'm hoping to work maybe with the Swiss branch. The Swiss have shown some interest in the arguments, but we would need a courageous, and not even one state, kind of like a group of states, because 1 state, 3 states, 5 states can get bullied. If you're taking on the P5 and you're in a small number of states, you get bullied. So it's almost like, and I saw this with the Act Code of Conduct, one of our voluntary veto restraint initiatives. It first started as the S5 initiative. And when 5 small states came out, they got bullied and they got, they couldn't get anywhere. So the next time Liechtenstein relaunched it, they already had like 23 supporters at their launch event. And that gave me the idea that, if you're doing something like honestly taking on the P5 veto, and in, US, UK and France haven't used their veto in recent years, but then they still, I think, protect that they have this power. They've only said we voluntarily, as a soft law initiative, won't use it, but they haven't committed to any legal limits. In fact, a Canadian official was using some of my arguments in the UK, and it triggered a Foreign Office denunciation. There are no legal limits to the veto. So, and that didn't work. And the French, I also was presenting, and someone from the French Ministry of Defense looked at me startled and said, but there are no limits of legality to the veto, as if I'm just delusional. So it's a difficult one. So I think I'll stop there. This is what I've been, my ideas, what I'm doing. It's hard to get, states to take this up. But I'm still, trying to present my book, and now the film at the UN in The Hague, kind of at venues where states will be. So I think I'll stop here and take questions.
Thank you so, so much, Jennifer. If I might use moderator's privilege to get us started, it seems to me that like death and taxes, many folks regard the veto as just a fact of life, an unfortunate fact of life, but a fact of life. And you've shown us, and we've described in this discussion already, some of the ways in which we see movement and the recognition that actually this is a human-made invention. When you trace the origins and the exegesis of the veto, we see all the ways that this couldn't have gone. I'm actually interested, as a side question, if you think that the principle of unanimity versus veto, if there is some power to that semantic construction. But in addition to the act and the France-Mexico proposal, in recent years, and you were heavily involved with this, I believe, we had the passage of UNGA Resolution 76262, which mandates a debate before the UN General Assembly if and when a veto is used. So we have kind of seen this momentum somewhat. Would you say that a particular resolution or the act proposal or France-Mexico has had any effect in an enabling environment for discussions of reform?
Yeah, so I don't want to, rain on their parade. I think they've achieved importance in that they've said, look, you shouldn't be using the veto in the face of genocide, war crimes, crimes against humanity. And if 2/3 of the UN endorses it, that's important, right? So that's really good. But they just don't go far enough because they've gotten UK and France to join. And in the end of the day, the other three P5 are missing. So we haven't really reined in the veto. So it's important. They really galvanize momentum. But I think, so they're soft law initiatives, which means they're not binding. So if you want to take the next step, to me, it is to try to get a hard law, looking at the hard law legal obligations. And the Liechtenstein initiative, for every veto cast, we have mandatory debate in the GA, also very helpful. It also states are looking at, well, why did you do this veto? Why are you vetoing humanitarian aid? So this is also very helpful in galvanizing a critical look, but they're often doing so more in political grounds. And I want to do so on much more legal grounds.
And I think I've heard you mention before that the fact that so many of your law students came to you and could see the glaring injustice really was a factor in writing the book. And yet, when it comes to state advocacy, I've also heard, Liechtenstein sat with a proposal for these bills in the desk, waiting for that right moment for years. And so you just have to catch on to it. I will point out that our friends at WFM Canada have seized on the second of Jennifer's two recommendations, the request for an advisory opinion by the ICJ, and are trying to well, we wish them the best of the success, are trying to advocate to the Canadian government to move forward with that, using as a lever or as a focal point the joint statement that Canada and other states made around the Russian Federation's use of the veto in light of the Ukraine situation. So I have tons more questions, but I get the privilege of talking to Jennifer more often than most of you. So I'd like to open this up if we could have some hands raised virtually or physically. I see Winston, please.
Thank you, Jennifer, for your very careful scholarship. And in particular, I think your implicit and perhaps explicit position that there are broader meanings that inhere within the Charter than those to which we seem to have traditionally subscribed, and that we must look for those meanings as part of dealing with this plague we call the veto. I like your suggestion about the advisory opinion from the International Court of Justice. But I wonder if we may not also, as a follow-up, or perhaps as a common front, look for a case that comes through the dissenting Japanese judge in the South African case, and the principle of good faith under Article 2 of the Charter, that member states commit themselves to act in good faith. And part of that good faith would be that one cannot suppose that the Charter gave member states authority to defeat the purposes for which the UN itself came into being. One of those purposes is to establish conditions under which respect for international law and obligations. Now, I think that the peremptory areas, just cogens, are axioms. It's like principles in geometry or physics or mathematics, if you wish. You cannot remove the axioms and expect that you can build any further. So I'm wondering whether you would support the idea of a confrontation under the good faith clause of the UN Charter, and in order to deal with the veto power. I must tell you, this is an area I'm exploring because I'm on work on peace, and I would love to talk with you in another context. So I'd not want to consume too much of our time here.
Yeah, great question. Yeah, I actually used the good faith clause in my book. I didn't make all the detailed arguments today, but it is one of the principles of the UN. I mean, there are a number of them. You know, the purposes include adhering to international law. Well, if you're aiding chemical weapons attacks, you're not adhering to international law. You have to cooperate in solving problems of a humanitarian character. You're blocking humanitarian assistance. You're violating that one. And you mentioned the good faith. And that one, there's actually, I think it's one of the ICJ cases, they're looking, I think it's a certain expenses case, and they're looking at, it's a challenge to voting on the GA to approve certain of the expenses of, I think it was peacekeeping, and they said, actually, you know, it's only cabined by like the good faith obligation. The vote is cabined by good faith. I'm like, ooh, you know, that's exactly what we're talking about. So I do argue, you know, the good faith is a little hard to use, but we do have some good law to say, no, this good faith obligation is there. You know, what exactly is a breach? Maybe more difficult. But yeah, you're exactly right. You know, is this good faith? You aid the siege, you block food aid, you aid chemical weapons use. You know, it's violating multiple of the requirements in chapters 1 and 2 of the Charter. Exactly. Yeah. Thank you.
Thank you so much, Winston. I have Alan next, and then going to Dave.
Thank you very much, Rebecca, and thank you so much, Jennifer, for your leadership on this, which is incredible. So I was involved in the campaign to get the issue of nuclear weapons into the International Court of Justice for an advisory opinion. So what, 25 or so years ago now, it's a while. And it has been incredibly valuable to take that approach. We now see that approach with climate change, with the incredible case that was led by World Youth for Climate Justice and the Pacific Island students fighting climate change. And if any of you were watching the public hearings in the first 2 weeks of December, it was just fantastic. Not only did you have the governments putting forward the political reasons, you know, for taking this case as an advisory opinion, and then the judicial experts, you know, from the governments, but you had youth really actively presenting to the court and doing a fantastic job. To me, this proposal is at the right time. if this had been tried 20 years ago, I don't think it would have worked. I know Judge Wheeler-Muttrey, for example, who was a judge on the court from 1991 to 2000, had pushed sort of ideas of judicial review of Security Council decisions and did not get very far. There was an incredible resistance to sort of challenging the Security Council by the court. But times have changed. And I think the Liechtenstein-Switzerland resolution, the UNGA, is one testament to that. The fact that on the International Court of Justice is no longer taken for granted that there will be a judge from each of the 5 P5 members. We don't have that at the moment. There isn't a Russian judge, there isn't a UK judge. So I think it's a much more opportune time to take this. And I think that the way that you've done this is excellent. It's not trying to do UN reform, which is to remove the veto power, which would be a huge ask. And there is a strong push for that with the Coalition for the UN We Need and various civil society. But I think there was a lot of discussion amongst civil society along these ideas in the lead up for the Summit of the Future. A lot of that facilitated by the Coalition for the UN We Need. So I think we have a rich array of civil society organizations that will be ready to come in behind this. Some may say this doesn't go far enough, we should remove the veto altogether, but I don't think that will stop them from supporting this initiative. I think they'll see this is a really good step to actually having a better Security Council. So I think it's the right time. I think the background that you've done to this initiative is excellent. My organization, World Federalist Movement Institute for Global Policy, is an endorser. I see we're up there on your website. Wonderful. So we will look at how we can help make this happen. I think there are a number of like-minded states that could be in a group, together. Individually, it'd be very difficult, but together there's power. And it's not just Switzerland and Liechtenstein, there's New Zealand also, my country, there's Canada, there's a range of countries, Japan, there's a range of countries, I think, that are influential. Sierra Leone is another really important one, I think, as you see, you've got already some experts from Sierra Leone. There are some other ones that can be built into the process. So I give strong support to this. I think what you're doing and laying out the legal framework for this is superb. And I think you're also addressing some of the political issues there, which is also really important. So sorry, it wasn't really a question. It was basically a comment in support of what you're doing, and basically say we're ready to support you and help in this process. And thank you very much for coming on to this. And thank you to Citizens for Global Solutions for choosing this as the book for us to sort of explore, how to take this forward.
Thank you, Alan, and thanks for all your kind words. And I think I skipped over something Rebecca said, but I just want to reflect back on that. She mentioned the Liechtenstein proposal for every veto cast, you go to the General Assembly. It had been kicking around for a number of years. And then, can't remember, it's Russia's invasion. Everyone was angry. They're really angry at Russia as a P5, and they suddenly passed Liechtenstein's initiative. And it had 83 co-sponsors. So sometimes it's timing, and you have to get the idea out there, and then some horrible veto happens, and then the states are just angry and they're ready to go with it. So yeah, it's often the timing. You see that the US had said peacekeepers are immune from the ICC, and they got that through 2 years. But the next year, the Abu Ghraib photos were in the media, and they didn't get it through. So sometimes something happens, and when you have the idea out there, then it's ready to go. So that's my idea. I still need to get the idea out there more. There's just huge turnover at the UN. That's one of my other difficulties. I met with maybe 35 legal advisors before COVID on this, and they loved my ideas. I turned around after COVID. They're all elsewhere in the world. They've resigned, they've retired, they've moved to different positions. They're in Nairobi. It's difficult. There's a lot of turnover at the UN, and there seems to be complete loss of institutional knowledge. So you can even speak to an ambassador. Costa Rica loved my arguments. Well, now we have a different ambassador. He had never heard of my arguments. The legal advisor had never. So it's a bigger problem of the UN that they're just, because of this turnover, you do advocacy, then the people change, And you're like, wait, where did my advocacy go? Well, it still exists, but it may be the legal advisor who's now in Beijing and not in a position to move it. So.
Well, thank you, Alan, and I'll try to contain my jealousy that WFM got listed on the website before CGS, but rest assured that CGS is a huge proponent of Jennifer's work and supporter. I have Dave Otten and then Susanna.
Thank you, Professor Trahan, for your book. I've almost finished with it now and find it very interesting. Up to on page 119, I was excited to see the Obama proposal about taking at least 2 or 3 permanent members rather than just one in order to have a veto. But for me, and I think for many others who have been world federalists for many years and involved in Citizens for Global Solutions, I don't know if we're as optimistic as maybe you are with how the UN as it is currently, as it was created and as it is currently constituted, could have any change to the permanent veto. That's why I think that I'm very supportive of the Schwartzberg plan that is involved in weighted voting to change the General Assembly and the Security Council. And I was wondering if you have come across the Schwartzberg plan, or if you're that much interested in changing the UN, or are simply trying to work with it as it's currently constituted.
Yeah, so I have decided I'm not going to try to see a change to the voting is actually a charter amendment. And those are really difficult. You need all P5 to agree. And I think it's ratification by, I don't know, 2/3 of UN member states. Maybe it's a very high threshold. They're very hard. We've only had one charter amendment ever. There used to be 11 members of the Security Council, and now there are 15. So I think 1965, it's incredibly hard. So I decided, okay, let's not try to change the charter, but go to another institution and get a ruling and try to adjust it from the outside. What can the rule of law, what can the judges of the ICJ say about this behavior? So yes, I have not gone for like a frontal assault. And I did an online book launch, and one of them judges, he's running for ICJ judge now. He said, but I'm defending the system that exists. I'm trying to fix it. I'm like, yes, I am. He said, we need a new UN. We need to get rid of the UN. So yes, I'm kind of working the structure. We have the structure. And, we've talked about changing the composition of the council and the voting provisions for 30 years. So I'm like, okay, let's try something else. So it doesn't mean I oppose working on changes. So, sometimes it's all of the above, right? So yes, work for, what the GA could do. How could you, but it's often small changes. The UN seems to work at small change, every 10 years you get something really, small. It's not these big things. So I'm certainly not opposed to trying to change directly, but I've decided not to try the UN, anything that involves a charter amendment. So mine is an interpretive question. Can you aid genocide through your veto power? It's a legal question. So, thanks.
And here I'll point out that at CGS, we are trying to walk and chew gum at the same time, while supporting Jennifer's track and advocacy tactics, while also some such as those that Alan alluded to, that the C4UN, among others, are embarking on. There is a impact coalition on UN charter reform that seeks to invoke the Article 109 Charter Reform Conference. And we also have on the table, with the Pact for the Future, the invocation of Security Council reform. It's not indicated what kind of reform that might be, But for the first time, I think, in quite a while, this is being talked about in a serious way. The Pact for the Future being the outcome document of last year's Summit of the Future, and I've put that link in the chat. And while it might be short-lived, given Monday's inauguration, the United States' position has recently shifted in a somewhat seismic way to include, in terms of the composition of the Security Council, to advocate for 2 new permanent members. And with that, I'll go over to Susanna.
I have a question that's totally outside of that. And by thinking of what are possibilities that are not within this wonderful arguments that Jennifer makes and that the book describes so eloquently. There are countries openly who want to tear the UN down. And they are not alone. I mean, we have quotes for that in the United States, in Israel, in countries that use political power. But on the other side of that, there are lots of countries that have now, unfortunately, experienced immense atrocities, immense genocide, civil war. I mean, is there a way of bringing countries that are vehemently interested in keeping the United Nations as whether it exists, veto or not veto, I mean, as an entity that has somehow held us together? Not good, not well. I mean, I worked on apartheid for so many years. Is there a way of approaching those countries that have had themselves experienced atrocity crimes to band together, to approach them for new arguments, for purpose and principle within the UN, and therefore the necessity to somehow keep that international group together as a way? I mean, the military always have the wonderful arguments, they fight together, like NATO, I think we say in English. There must be ways of bringing these countries together because they have had all that suffering. And it is interesting that I think in many occasions, those are the people who have very good ideas for reconciliation and for keeping moving forward in a positive way.
Yeah.
That organization.
Yeah, thank you. That's a really good question. In my film, I have a Syrian speaker, and you know, he has much more credibility than I have to talk about what the vetoes meant to the people of Syria. You know, he was held in detention. I mean, this is why I have him in the film. So it's not just me saying, okay, these were horrible vetoes for Syria, but I have someone from Syria. Well, we have a new government in Syria. You know, I used, you know, in the past, I would say, yeah, okay, the Assad regime won't be joining my bandwagon. We have to kind of wait and see who they turn out to be, because yes, perhaps they could. So it is potential. You know, that's why, yeah, you know, and my approach is to try to, you know, stay with the UN we have, imperfect, and try to make it perform better, because, you know, the one thing, the P5, you know, in using their vetoes, you know, they obviously relish this power, but I kind of feel like each time they do, they undermine the whole institution to some extent, and everyone gets cynical about the council, and then the general public doesn't differentiate council. They just know the UN isn't doing anything.
Yeah.
So often the veto power of the P5 why the UN isn't doing something. So I think, you know, they're marginalizing themselves. And then you do go to the General Assembly because you're like, okay, you're just not going to be able to do anything related to Ukraine. So we'll try to go to the General Assembly, but there are real limitations on the General Assembly power. So, you know, in the long run, you would think Russia and China and the US might think about, but obviously, you know, they have overriding concerns, but with each veto, I feel like it chips away at the legitimacy of the institution. And it makes us all more cynical. Ellen,
Yes.
yeah, did you have thoughts to add?
I'm so struck, Jennifer, by your very compelling story of what brought you to this issue. And that was the questions and comments from your students. Similarly, the issues that came before the ICJ for those 2 weeks in early December were brought forward by young people. That's the moment right now. And I'm not hearing that a focus on young people bringing this issue forward has been taken yet. And I would really encourage that. I would encourage that a group of young people who really understand the tremendous harm that is accruing to their own futures, similarly to the compelling arguments of the young people with arguments regarding environmental devastation, be brought forward, and that this could be a remarkable opportunity in front of the ICJ. They are the ones whose futures will be cut short because of the veto.
Thank
Get
you.
your students.
Yeah, that's a powerful idea. In the film I am teaching, I have 3 students I'm interacting with. One is from Sudan, and the one is from Mexico, of course, behind the French-Mexican initiative. And the other, she's Muslim and she's from Singapore, but I know she felt very strongly about what's been happening in Gaza. So I felt those students all felt the vetoes very strongly, but I do need, somehow to harness that better. I energize my students, but I need to, that's a powerful idea, Ellen. Thank you.
Yeah. And to somehow incorporate those voices in as public a way as you can. That's the attention-getting moment. There you have it.
Thanks, Ellen. I have to think and work about that.
And perhaps there's an area of concrete cooperation there. CGS is launching a national youth network, and we've had an outpouring of interest in the Law Not War program around the ICJ and advisory opinion process, as well as support for the ICC and opposition to sanctions. And we have in our midst already a couple of applicants for positions, one of whom has had the fortune to be from Iraq, live in Syria, live in Lebanon, and now be a human rights student who, well, I think she's just graduated actually with a master's degree in human rights, who I met at International Law Weekend last year. And then we have our friends from situation countries, such as Aryeh from Ulag. When I think of an impassioned young person from a situation country with a powerful, powerful voice, I think of him. He's going to be in DC in a couple of weeks with the Human Rights Watch delegation, and perhaps we can discuss there. He's been looking for ways to coordinate. Alan had to leave, but Alan, of course, is the program director for our global counterpart. And so we've been discussing ways to try to integrate youth throughout the world, not just in the United States, in this effort. Oh, Emma, great. I do see your hand. Thank you.
Thank you, Jennifer. I'm really soaking all of this in, and being one of those on this panel without a legal background, sometimes I am overwhelmed. But overall, thank you for the efforts that you're putting into this. It's really noteworthy. The question I have for you is, do you see increasing the representation at the level of the P5 UN Security Council as changing anything at all, be it the proposal that Jennifer just shared with us, with the US supporting 2 seats for Africa and probably 1 for the island states, as fundamentally changing the dynamics of things as you see them. And furthermore, if one understands that form follows function, if anything fundamentally is going to change, even if we open up the space for decision making to enable the veto power not to be such a tool to promote, as you've put it, crimes when one member decides to exercise that veto power. What are your thoughts around some of these proposals out there to
I think
include
I
participation?
Rebecca, we have to walk and chew gum. I certainly don't oppose them. Having an African seat, totally, yes, absolutely. Small island nations, yeah, sure. But it doesn't solve the veto. So I still have to, we still have to tackle that one. So we can work at things multiple different ways. I think increasing representation, yes, this helps. But as long as the P5 have the veto, which they have under the charter, so we're either going to reform the charter or get an interpretive question from elsewhere. You should not be, you should not be using the veto this way. So I did submit my questions. I see Rebecca in a private has said, I submitted my arguments to the moot court competition for the global moot and was not selected. So I put in a proposal that students around the world do a moot court of my arguments, pro and anti. There are legal limits, there are no legal. I did put it into, there was a selection process and it was not selected. So I see you ask, oh, could you submit for a moot court? I did that this December, I think it was, early December 1 or something was my deadline. And I put in a proposal. I just to engage students around the globe debating pro and con. Yes, we think alike, Rebecca.
Indeed. It's unfortunate that it wasn't chosen, but maybe I could still socialize with the students on the margins and try to recruit them to the efforts.
We don't have more on the veto. Maybe we should just take a few minutes, Rebecca. We'll talk about, I'll talk about the crime of aggression very briefly, and we can both talk about sanctions. Might be of interest to this group. Not, and if others have veto questions, but I don't see any raised hands. So one of the other things I do in my spare time from teaching is I run the Global Institute for the Prevention of Aggression. This was started by Dawn and Ben Ferenz. I know Suzanne and probably Ellen will know that maybe many of you will know them. And Dawn retired a couple of years ago.
Jennifer, Ben was actually a National Advisory Council member and a founding member of.
So you all know Ben.
Before his death. Yeah.
So then, so Dawn, his son, formed this group, and before Russia invaded, said, "Hey, I want to retire. Would you take this on?" So I did, and then Russia invaded. I'm like, "Oh boy, I got to do something with this group now." So we have been. I'll put the, or Rebecca, maybe you find the link to the Global Institute for the Prevention of Aggression and just put it in the chat. So I have added to our executive council Fatou Bensouda, and the ICC former prosecutor, Richard Goldstone. I created an executive council, Liechtenstein ambassador, Christian Veneweser, Hans Karel, etc. And then we have about 50 council advisors committed, and we're mainly crime of aggression scholars. And what is coming up is actually very important. In July will be a review conference, a conference that's a review. It's not a review conference. But of the statute of the International Criminal Court that grants jurisdiction to regarding genocide, war crimes, crimes against humanity under one regime. And then for the crime of aggression has very little jurisdiction. And basically the US in 2010 in conference in Kampala reduced the jurisdiction, and then the UK and France in 2017 squashed it even more. So we've like this tiny bit of jurisdiction. So you might have noticed, you know, Russia invades Ukraine. Ukraine adopted the Rome Statute, accepted the jurisdiction now as a state party, earlier accepted, but it only created jurisdiction over Russian crimes of genocide, war crimes, crimes against humanity in Ukraine, but not the crime of aggression. So it showed, wait, you know, this supreme crime that they called it in Nuremberg has this tiny bit of jurisdiction. So one thing I've been engaged on with states is trying to create a separate aggression tribunal, but we're also trying to fix the Rome Statute. And I'm pleased that our group, the Global Institute, we put out an amendment proposal, and it is one of the proposals texts that has been shot to all states now. And it will go through a process in the spring called the Working Group on Amendments. We will, and then I believe I just yesterday volunteered to create a huge conference at NYU prior to our July review, which is only 3 days, to try to work on this amendment and create more jurisdiction. It's a difficult endeavor. Last time the US, UK, and France were opposing crime of aggression jurisdiction. They apparently want to be able to invade without legal consequences. And I'm sure Russia and China would line up with them. So unfortunately, we're still with the kind of P5, the rest of the world dynamics. Many countries feel strongly the crime of aggression matters. They don't want to be invaded. So just numerically on the global stage, there are more small countries, and they care about this crime of aggression. 47 have ratified the amendment. And, you know, unsurprisingly, Denmark just ratified. Well, who's saying we might invade Greenland? Okay, this is not surprising, right? Norway's about to ratify. They, you know, so Nordic countries are really freaked out about Russia's invasion, interested in joining NATO, and they suddenly really care about crime of aggression. So small countries care about this crime. They said, we don't want to be invaded. We need this. The big powerful countries don't like this crime. They might want to use military force, and they don't want any lawyer asking pesky legal questions or the ICC. So it is a difficult dynamic, but there are more small countries that want to get this through. So we're trying to reharness that momentum and reach out. The Germans are leading this, and they have arranged conferences in Africa, Central South America, and Asia to try to get, you know, other regions involved in this. We saw Rebecca when we were in The Hague, civil society group AFLA from Africa interested in this crime of aggression, and they had a number of African ministers saying we need more jurisdiction for this crime of aggression, you know, and why this, you know, this is all about Ben's legacy, law, not war. You know, Ben prosecuting at Nuremberg, you know, he saw firsthand, he liberated concentration camps. He saw the harm of war. And in the Nuremberg judgment, this is a longer discussion, not a 5-minute thing, but so I'm doing the 5-minute version. You know, Nuremberg and Tokyo tribunals prosecuted the crime of aggression, and they deemed it the supreme international crime. And the idea is it sets off all of the other harms. So if Russia hadn't invaded Ukraine, we wouldn't be dealing with war crimes in Ukraine. We wouldn't be dealing with crimes against. We wouldn't be dealing with billions in rebuilding needed. We wouldn't, all the other harms that have happened to the Ukrainian people that aren't war crimes, crimes against humanity, and including the deaths of soldiers on both sides. And this is how the crime is different from laws of war and war crimes. So under the laws of war, you can kill soldiers. That's how the laws work. But for crime of aggression, they are victims too, because it's an illegal war, and we have Russians dying, Ukrainians dying. We now have North Koreans dying in the, so this is the harm of the crime of aggression. And it's coming up, you know, the review conference is coming up, and civil society has been really, the big civil society actors have been really absent. Human Rights Watch, I used to work there years ago, and they said, you know, aggressive war, not a human rights issue, not our issue. Amnesty International has said much the same. Well, Volker Turk, High Commissioner for Human Rights, in a tweet, war is the worst enemy of human rights. I can't put a tweet in the chat. I don't know if this is visible.
That's
War
right.
is the worst enemy of human rights. I feel like taking this, you know, on a stick on a slogan and parading around the Human Rights Watch offices when they said it's not our mandate. War, you know, that's not a human rights issue. And Amnesty International never took this on. Now they're different. Amnesty's changed, different leadership. They're more interested. I've spoken with them. Still not making great headway with Human Rights Watch. Very tepid support gradually. So it's a difficult one. We have only really had interested, it's been more academics because it's the law of going to war that maybe human rights organizations are not familiar with. But some academics have been spearheading this, and they are now part of the Global Institute for the Prevention of Aggression. So Rebecca put the link. Oh, you found Sina's tweet. Thank you. And the group, Crime of Aggression, is that us? That is us. Yeah. So this group. So we're working on it. We're working very much with Liechtenstein, always on the good side of things. And now we are trying to convene an NGO team. The CICC has a team, and European Center for Human and Constitutional Rights also sees this as important. And they have an NGO sign-on statement, and they've been convening CICC team meetings. So civil society belatedly is getting small NGOs on and still not the big human rights organizations. So we're only talking aggressive war and how many millions die over, you know, this is a huge question, huge project. So that's my other initiative that I'm working on, the crime of aggression. And it's very much something the US government is against. You know, they have asked me to stop my work. And, you know, one of the good things about being in America is you can ignore this and you don't go to prison, at least. It may means you're never put up for any important appointments, but at least in our country, so far, I say this on January 18, so far, you don't go to prison for your views.
So Jennifer, I think it might seem self-evident, but the definition of the crime of aggression, of course, in the Rome Statute, relates to individual criminal responsibility, because that is, of course, the jurisdiction of that body, the ICC, as opposed to state responsibility, which would, one would think, fall back upon the principles of the UN Charter and, in fact, the very rationale for the raison d'etre of the UN system.
Which doesn't work when you have a P5 committing the aggression. So
Exactly.
that's full circle. It does relate to the veto. So the crime of aggression is based, part of the text of the crime is 2.4 of the UN Charter. So it's saying when a state invades, and they don't prohibit self-defense. So Ukraine acting in self-defense is not covered, of course, or a Security Council authorized intervention is not covered. The crime is basically enforcing the UN Charter. But, you know, and there is a state responsibility level, and we would hope the Security Council takes it on. But if the P5 is invading, or they have an ally they're protecting, the council doesn't work. And then we're not having individual criminal responsibility because we have this tiny bit of jurisdiction at the ICC. So right now we're having like, it's very political. Yeah, you know, we're not having rule of law. We are having, yes, you could put the EU and US put sanctions on Russia, but that's as their political decision. We're not having our machinery of the rule of law able to work.
And we have 1 minute in our allocated time. Jennifer, I know we got a little bit of a late start. Maybe you can stay on for.
Sure.
Okay, and hopefully our book club participants can as well. It is, of course, also deeply ironic and deeply saddening that law, not war, that refrain really led to the project of international law from 1945 on. But when we look at the crime of aggression, and I've heard Jennifer correct others on this, the crime of aggression is very much in the 1998 Rome Statute, but it's there as a placeholder. We'll get back to this. And then the 2010, think about that. 2010 was the review conference that Jennifer was referring to in Kampala. And we've still, in 2025, got these major lacunae. So there is some massive work to be done. And speaking of work to be done, Jennifer, in our just last couple of minutes, if you wanted to mention the amazing advocacy you've done, including the recent statement issued by the New York City Bar Association, which is quite a momentous achievement, on the threat of sanctions on the ICC, that would be
Well,
great.
I think my work pales in comparison to yours, Rebecca. So probably those on the call, I know at least Susanna and Ellen are on the WIC emails, so you know the sanctions. So for others who maybe aren't aware, the House has passed sanctions that anyone who against the ICC, it is targeted so far, their version, to anyone who works on the Israel-Palestine investigation or prosecution of US nationals, which is not happening right now. The Senate is going to take this up. They could pass that or a broader version. Trump may pass it as an executive order. And it could be a broader version. It's intended to bring down the International Criminal Court. They don't want Israel being prosecuted. The charges are using starvation as a weapon of war. And they would like, the court to, it's strong arm tactics. And, regardless of what you might think of the Israel-Gaza situation, we think it is going to harm the whole court because there are many systems the court relies on. It's not like it has IT for Israel-Gaza. So Microsoft does their IT. If they can't do IT for the Israel-Gaza investigation, they can't do IT. And the court has no IT system. So the court, is brought to its knees. So that is the intent. So we're waiting to see the final version. All we can do, Rebecca and I and others, is try to make statements opposed to this. So I work getting one out, New York City Bar Association, American branch of the International Law Association, International Human Rights, IHL, International Humanitarian Law, Gabor Rona got them to do a statement. Rebecca has done a brilliant sign-on. You have over 120 states.
126, but who's counting?
126 American NGOs, faith-based organizations saying don't strong-arm the court and harm it. And now the Coalition for the International Criminal Court, CICC, has a sign-on with, I think, over 100 NGOs globally. Don't strong-arm and don't put sanctions. And this is an echo of the sanctions from the last Trump administration, where he put an asset freeze and travel ban on the chief prosecutor Fatou Bensouda and Fakiso Mochochoku. But it was really anyone, and it was worded more broadly. It wasn't just those two. But, when you have a travel ban and asset freeze, like you're a non-entity for banking purposes, and they could easily target the entire court, and then the court can't bank, it can't do IT, it can't fly because, you can't try. I mean, it's really designed to make sure the court, and this is the court, regardless, I presenting to the New York City Bar Association, I got some views. Well, the court should not, should not go after Israel. And I had to say, okay, let's step aside from this. It's the same court that's going after crimes in Darfur. It's been prosecuting LRA. It's been prosecuting Congo. I mean, it's going, looking at atrocities worldwide, and it's at risk of not being able to operate. So you're harming the interests of the victims from Myanmar to Sudan to Venezuela to all around the globe. I argued with one congressman last week, and, till I was blue in the face, he would hear none of it. So they do intend to bring down the court, and it's really reprehensible. And so this is what we're facing right now.
Thank you so much, Jennifer. And
Sorry to end on that dire note, but that's what Rebecca.
indeed. Well, there is still time to act. The Senate Foreign Relations Committee will hear this legislation probably this week. And we don't have the best of hopes, but we still, as always, persevere and must continue. Our friends at Peace Action, I can send this to anybody who would like, have a script and a call your senator action alert. So I can send that to anybody who's interested. And I've shared all of the, not all of the, excuse me, the statements that were mentioned, with the exception of Gabor's. I didn't have that quite handy yet, but including the New York City Bar Association, the Coalition for the International Criminal Court, and that CGS / the Washington Working Group for the ICC led that Jennifer mentioned. So with that, Jennifer, thanks for staying a couple extra minutes, and thank you so much for your inspiration, for your indefatigable work, for your scholarship, for the opportunity to learn from you every single time we speak. And thanks to all of our book club participants. I'm also delighted to see fellow authors continue to join these sessions, as well as new members and old friends on our board. Our next session will be in February. It will be a Saturday at the same time, but the date TBD. And we will be inviting authors from our journal Mondial, which is co-published with the World Federalist Movement Canada. And so we did this last year for the first time when we had an issue of Mondial go out. And so there'll be several presenters speaking about shorter articles as opposed to our normal full book format. And then we plan to go back to our regularly scheduled programming from there. So with that, I'll stop recording, but I am very happy to stay for anybody who wishes to speak.
Thank you so much, Rebecca. Thanks, everyone.
Thank you so much. Thank you so much.